Hi there, folks. This is Sam Price, and I'm welcome to another episode of Probate Notes. I have with me here a really great guest that's going to give us some insights on how to resolve some disputes when it comes to trust and estates. I have Daniel I. Spector, trust and estates mediator and reformed litigator, and he is a partner with Hanson Bridgett and a neutral with Judicate West. Dan, thank you so much for being here with me today.
Sam, it's my pleasure. It's great to see you.
You know, first thing I kind of like to start off with is just kind of understand a bit more about you and your legal career. How did you become a lawyer, and what was that? What were your thoughts on doing that?
As I was growing up, I became aware that I had a limited set of personality skills, coupled with personality defects. And so the ways in which I could be productive narrowed as I got older. And one of them was to go to law school. I was fortunate in that I had an uncle who was a lawyer, and I spoke to him about it, and he confirmed, yes, you've got the kind of personality and skill sets that might make you a good lawyer. And so I tried out some law jobs when I was an undergraduate and really liked it and liked the process of being paid to kind of think, and as opposed to, build stuff or do so with my hands. And so I ended up going to law school. And once I got to law school, I certainly felt I was amongst my people. And then once I got out of law school, I continued to really kind of chase a practice where I was in the midst of problems and problem solving. I've always known, since I went to law school, that I was comfortable in conflict. Not that I sought conflict, but comfortable in conflict, trying one way or another to kind of resolve the problem, either one way or another. And so that drew me to litigation. I spent the first, I've been a litigator since I graduated law school 30 something years ago, almost 35 years ago.
Can I ask you where you went to law school?
I went to law school in Santa Clara.
Santa Clara, okay.
Did my undergrad at Davis. Went to law school at Santa Clara. And then
Are you from Northern California?
Yes,
Okay.
I grew up in the Bay Area.
Yeah.
And then went to undergrad at UC Davis. And while I was at UC Davis, I never once was in Sacramento. I had a bike. And so I had everything I needed in UC on campus.
Is there a big difference between maybe a mediation in the probate space as opposed to regular litigation mediation?
I think so. Keep in mind, my experience as a mediator is almost exclusively limited to trust estates, financial elder abuse, and contested conservatorship matters. I have certainly handled or other types of mediations, but they usually involve families fighting amongst each other. My understanding is that when you have a mediation involving, let's just say, two business institutions fighting over a contractual right, the fight is just it's not personal. And so it's much easier for the parties to make a literal and figurative business decision about how to resolve the case. Whereas in trust estate litigation, we're fighting not just over money, but it's the meaning of the money. The fact that one brother gets more money than the other is oftentimes construed as that his parents loved him more than the other brother. And that's extremely difficult to cope with and manage and work through in a mediation. But we do. And we do it, and there's a space to do that in mediation. There is no room for that in litigation.
Do you find that when the parties are either listening to something communicated from the other side or from you, do you find that they're listening just for the purpose of responding or rebutting what is said? Or do you feel that they're really absorbing what is being communicated back and forth?
I'm smiling because your question is so spot on. So it's very common for me to introduce the concept early in the mediation that today we are listening for the purpose of understanding, as opposed to listening for the purpose of rebuttal. And that's as much a reminder to the parties as it is the lawyers. As litigators, we're really good at listening for purposes of rebuttal. We've been doing it since we were kids. But that's not really the type of listening that is useful in mediation. In mediation, we're engaging in listening, but it is not for the purpose of making a counter argument. Counter arguments don't have a whole lot of place in mediation. In mediation, we are seeking compromise collaboratively, and that's based on an understanding. And so I ask people to listen for the purpose of understanding. And most of the time, most of the people can do that, but it's a shift, and it requires kind of an intentional effort to engage in that type of listening, particularly when you're in somewhat of a defensive posture. You're in a fight, you're in a disagreement, and you're in this process, this mediation process that's in the context of that disagreement. So I'm asking people to take a time out from the rebuttal, from the fight, from the litigation for one day, and to try to understand each other by listening to each other.
What advice would you give someone who wants to be a mediator?
Well, I was thinking about this question because I had a feeling you were going to ask it. And there's a couple different paths to becoming a mediator. One of the paths is to be a judge. And so few of us become judges, but if you become a judge, the mere fact that you were a judge seems to be a pathway to be a neutral. Now, I personally, I have lots of friends I have friends who are judges and friends who are judges who are neutrals. I feel that when you're a judge, you spend approximately 20 years before you're eligible for retirement judging things. And so they're really effective at judging things, assessing credibility, and making decisions. That's a really effective set of tools to have when you are a private arbitrator, a private jurist, in those instances. Mediation, there's no judging, there's no credibility assessment, there's no deciding things. So I tend to choose when I'm an advocate, I generally rely on mediators who are, like me, reformed litigators. So I generally, if you're a litigator, let me start here. Sorry. I think mediation is a method of conflict resolution. So to be a good mediator, you need experience in conflict. That means that most of the time, the best mediators are former litigators. I'm not saying that you can't be a good mediator as a transactional lawyer. I'm sure you can. And I'm sure there are some fabulous mediators who are former transactional lawyers, but mediation really occurs within the context of conflict. And as a litigator, I've spent years, decades in the trenches, in conflict, shoulder to shoulder with my clients. I know what they're feeling. I know how to guide them through the minefield that is litigation and mediation. And so I have that experience, and it's that experience that informs someone to ultimately become a good mediator. So it's experience with conflict, experience with resolving conflict and leading people, help facilitating people through the conflict. I think mediation, a critical component to being a good mediator is being a very good listener. I've always viewed myself as being a better listener than a speaker. I'm a pretty good speaker, but I'm a really good listener. I think mediation is a place where that skill shines. There's all kinds of different opportunities for mediation. In trust and estate mediations, I think it helps to have depth, substantive depth in the topic. It's a complicated area, as you know, Sam. And so when you're facilitating a resolution, it's important that you have substantive depth in the law, in the legal processes, but also the family dynamics that live and are repeated in these cases. So I hope that answered your question.